Good afternoon. My name is Harold Furch Scott Roth at the Hudson Institute, Center for the Economics of the Internet. I am pleased to welcome you to this event at the Hudson Institute. We are pleased to welcome today Thomas Hazlett, the H.H. Macaulay Endowed Chair in Economics at Clemson University. Professor Hazlett is, in my opinion, the world's leading expert on the economics of spectrum. His most recent book is Political Spectrum, published by Yale University Press. The Federal Communications Commission later this month, and this is April 2020, is going to be considering a proposed order that would open up 1,200 megahertz of spectrum for unlicensed use. This is the largest opening of spectrum for unlicensed use in history. It's a very important event. At the same time, the FCC is looking for spectrum for licensed use for 5G applications. There were proposals to reserve some of this 1,200 megahertz for licensed use, but the Commission decided not to do that. So we're pleased to have today with us Professor Hazlett to discuss the economics of spectrum and how the FCC ought to be thinking about some of these things. So Professor Hazlett, tell us a bit about what the FCC is doing. Is this just a battle between licensed and unlicensed services, or was the Commission correct to decide to open it up for unlicensed use and not reserve anything for licensed applications?
So that's a great question, and there's a lot of parts to it. The general stretch in terms of public policy, starting with the 1927 Radio Act, is experience of overly restrictive rules, which is the regulatory reflex under the public interest standard, which was the brainchild of Herbert Hoover. He knew it would be a very political system, and he liked the politics that it would imbue. And we tend to actually dictate what happens for particular applications and services in the marketplace. Over time, that increasingly became obvious as an expensive anti-consumer, anti-competitive system. And the system has loosened up in recent decades. And certainly liberalization of the rights that we authorize, allowing, for example, licensees to get very broad assignments to use radio spectrum and to devise the architecture of their networks and determine what services or business models, what technologies can be adopted, so long as they are essentially within a defined space. And so wireless has taken off in recent decades. Part of this has been a relaxation of some rules that are attached to government assignments or set-asides that also have some kind of the old regime, the traditional system where the government defines what is going to take place in spectrum, but also has relaxed some technology choices and business models. And that's been to the good as well. It hasn't solved all the problems, but it has allowed a lot of useful services to come in without the so-called mother may I approach breaking that and having this very costly social drag between the time consumer demand is a glint in an entrepreneur's eye and some innovation can come to market. I want to point out there is a mistake in the FCC's order that it's recently issued, the proposed order, which is that it says that it opened up the ISM bands, which are 2.4 gigahertz and 5.8 gigahertz, now widely and popularly used for Wi-Fi services, that it actually created the unlicensed assignments in 1989. Now it's a little alarming. The FCC doesn't have a better handle on what its history is, but that was not the case. What happened? There was already an unlicensed band set aside. What the FCC did was to relax the rules specifically so that a whole new family of technologies could come in, spread spectrum, and that led 10 years later in the late 90s to Wi-Fi entrepreneurs being able to attach, routers in home broadband systems. And as you say, the rest is history. There was no regulatory barrier allowing that innovation because of a relaxation. So within the unlicensed space, you have had progress with more being able to be done. But there are many things that can't be done when the rights assignment or usage rules are still configured in an unlicensed manner. And so if you look at what's happening here, there is this very large swath, as you mentioned, excuse me, for gigahertz, that overall 1.2 gigahertz, that is being opened in a sense to more unlicensed use, and the sort of under the rules that may actually work well with Wi-Fi technologies, but there are restrictions. Of course, there are power restrictions. In some part of the bands, there's a 4-watt restriction. In other parts, there's a 1 watt. There are technology rules that the devices have to carry with them a communications ability, in addition to communicating with their customers, to communicate with controlling devices. And so there is the automatic frequency control that has to be like a database assigner, a database that assigns what frequencies are open. Now that's a network management function that of course is provided by base station controllers and cellular systems and in other types of regulatory structures where you have companies being given the property rights to configure the business models and technologies. Here, what the FCC does under the unlicensed regime is it makes its own rules and fixes those in law. Now, that turns out to be a very large difference because over time, we have to see if these rules work reasonably well. Maybe there's a less costly way to do what the FCC is trying to do, to allow more use of that spectrum. That's certainly a step in the right direction. The problem is they don't consider, and you could read the order, they don't consider the real opportunity costs of this. There's no serious economic discussion. There is what I call asymmetric triumphalism, pointing out that certain popular uses, particularly Wi-Fi here, have gotten out in the marketplace and provided value. And it's just the assumption now that more spectrum, additional spectrum, would do the same. That is an unproven assumption. It likely will host some activity, but will it do more than the alternatives? Will there be other ways, other set of rules, whether it be more like on the exclusive rights model, which has competition between carriers and an auction to have more 5G services or other things like that that can be optimized in a way to have more sharing of the spectrum, but do it in the competition between private firms applying technology? Or would there be other ways to have unlicensed services that have different rules, different power limits, different kinds of communications and coordination so that they don't destroy or dissipate the resource by interference? So this actually fixes in law a particular sharing arrangement, and that's why I think it's problematic, and the regulators should be searching for much better ways to do what they're trying to do.
Doesn't the FCC hear from different parties with different interests and collect a record? And if there were different types of technologies out there, is the commission in a position to demand for the spectrum from these different parties?
Yes, the FCC does take into account the views of the interested parties. In fact, that's the only way that the FCC can get any information at all, basically, that's relevant to the policy margins on which it wants to make decisions. That is, the regulator with wide and no state-of-the-art laboratories and no entrepreneurial venture capital, no kind of market institution. I mean, that's not what they do. That's not how they're set up. It's not how they can be funded. The FCC has to rely on the interested parties to tell them what they want, and those parties, whether they be carriers or tech companies or cable TV operators, telcos, the the parties will put in very good information about the technologies, and it will of course be slanted from their interest and ask for policies that would be good for the firms and interest groups that are submitting the information, and the regulators read that, and they do get fairly well informed. What they don't have is a real trade-off model between the costs and the benefits. However, they have studies which have been submitted in various records for unlicensed that will not do the economics, not consider the substitution effects. If you don't have this spectrum allocated for unlicensed, what else will go in there? If you read the order, it says how explosive growth is, and how indispensable these services have become. Well, those are just expletives. The fact is that you can say the same about other services, 5G, for example, and explosive growth, and there are many similarities, which are in fact a point made by the FCC. The question is, at the margin, going forward for the next 100, 1,000 megahertz, whatever the next increment is, how can it best be utilized? And adding up the value of services, or how much traffic and physical units there is, which, by the way, is always misdone. They never count the distance. They always say what percentage in these triumphal statements about Wi-Fi in particular. They'll say how much traffic, 60% of cell phone traffic ends up being offloaded to Wi-Fi. They don't talk about what the distances are. If you want to do a physical measurement, you would logically presume talk about how far the traffic is carried through the air on a cellular carrier network, which uses exclusive rights spectrum. So the calculation about what the actual value in one use, say regulated a certain way for a certain type of application that comes under the Wi-Fi definition versus any other use, that is not information that is easily discernible, or even with difficulty discernible, from the comments that are submitted to the FCC. They come much more in the revelations of the firms that are betting real money and try to engage in real experiments in the marketplace. And it's why some FCC economists and others of us have actually advocated that unlicensed, as we think about it as a kind of plug and play model that does not have a network built by a network provider, but is dispersed and sort of bring your own network kind of application, that those kinds of allocations of spectrum should be made, as are many others now, on a purchase basis in the market, so that there would be arm's length auctions that the FCC would arrange that would allow that to be the business model. That might take the FCC stepping back from things like build-out requirements, which do bias the outcome of the auction in favor of a different sort of business model. I'm certainly in favor of that. It's a very simple idea. Technological neutrality. It's very popular in regulation all over the world. Don't try to tell the market exactly how to build things. Let consumers decide between the various options available through entrepreneurship and science. And so that is what we need to move towards in terms of getting this extra spectrum out and in its highest valued use.
Professor Hazlett, could you tell us a little bit about how an auction for unlicensed would work mechanically? How would that work?
It would work the same way the existing auctions work. It would be optimized or tweaked, in my belief, by rules that did not foreclose operators coming together, firms or parties coming together. They don't have to be considered operators, to buy rights to use in the marketplace, just as the rights today, say for what we call 5G auctions, are used by carriers. Now, probably the biggest policy issue on this is to not look at build-out requirements as a mandate, because this would be a situation where the business model would not focus on a network but would focus on a set aside of radio spectrum that would be locally used to complement other networks.
I see. And you think this could be applied in
Fiber.
6 gigahertz as well?
Oh, absolutely. So people have their home networks, and then carriers, or they say other parties, tech companies could get together, presumably in a consortium, and buy the rights to, it could be this band or any band, 100 megahertz, 1.2 gigahertz, and say, look, this is our park, and we're happy to provide access. Any manufacturer who makes a device that accesses this spectrum, we have a long-term commitment to make this available. We have contractual guarantees for those who come into our ecosystem, and we will charge a 1% or a 2.5%, whatever the reasonable and optimizing license fee is, and you recover some of the opportunity cost through a market mechanism.
So, Professor Hazlett, let me see if I understand this correctly. So, we don't need to have sort of a command and control system where the commission says this band is open to unlicensed and that band is not open to unlicensed. Under these specific conditions, we could have these determinations made through an auction system that would allow prices to dictate the best and highest value use of spectrum. Am I understanding you correctly?
Absolutely. And so then you'd get market demand revelation in the auction, not just to assign licenses, but to assign uses. And you'd have much broader competition between different options, different styles or business models. And that's exactly the way you want things. And of course, to a very great extent, we've achieved that with liberal licensed spectrum, that there are different business models that are applied, different ways of doing IoT and doing MVNOs and having the contracts with customers and the way networks are built and the services they provide and the technologies they offer. That liberalization needs to be extended to what we call licensed, unlicensed. And I'll point out that under the unlicensed rubric, we have lots of battles in the United States going decades now where it's unlicensed versus unlicensed. And you have that in the 5.9 gigahertz band where the unlicensed services, it's licensed by rule, which is really, it's an open access regime with a registration system, that you have that for optimized for cars or automotive telematics and so forth in 1999. Now the FCC says, well, that's after 20 years, that's really not working very well. We want to go a different direction, open that up to Wi-Fi. Well, you have, it takes, the reason it takes so long to figure out that maybe that wasn't the right decision 20 years ago is because this is all tied up in a regulatory proceeding. How much better if rights were liberalized such that they could flow naturally in the marketplace as we've seen them flow. And as we've actually seen, for example, TV stations, when they have the right to sell out, they sell out to the wireless broadband. So the whole T-Mobile network, they're advertising now, first nationwide T-Mobile network. That is a product, not just of the incentive auction, which was a switch in use from TV to something different, but it was early in application because the T-Mobile licensee was given the opportunity to pay the TV stations to go dark, to go off of one technology and to open up another. We can do exactly the same thing, and in an auction framework, the bidders and the consortium idea, of course, is very strong here because there's a whole ecosystem that is pushing for access to greater spectrum for unlicensed applications. So in 2006, you had a consortium bidding of 4 cable companies bidding for nationwide spectrum rights to apply an opportunity for cable operators to go into the mobile business. Those companies bid as a consortium. They had rules I was one of the consultants for one of the firms. And at any rate, they were successful in the auction. They put their pennies together, and they had complementary spectrum rights that they ended up purchasing nationwide, luckily at a very good price. But the point was, they were able to bid. They were able to come together as a group and reveal the value to them versus other users of that spectrum, what things were worth. Now, when people make this claim that we have at the margin a very high demand for more spectrum for Wi-Fi, which may be the case, that they put together a business model that allows some revelation, not just a lobbying effort that involves lawyers putting words on paper that appeal to regulators, but actually trying to target a customer demand where there will be a very exciting and positive response from the market, from the manufacturers of devices, and then from consumers to buy and use those devices. There may also be services, subscription services. I'm sort of assuming the other side of it because people don't think of unlicensed that way. But any kind of a business model that can be put together that reveals demand will enormously help the system be much more flexible and liberal. And the biggest payoff at all is not just that you help the FCC figure out what the highest valued use is today. You put the rights in the marketplace in a very responsible way where the rights have owners who are very attuned to the new technologies and the new business models, the innovations that will come, and can then switch from some old system to a new system that's 10 times better. Now that, eliminating lock-in, is exactly what the FCC should do. And by the way, this, just because it's unlicensed doesn't mean that there hasn't been a lot of very socially inefficient lock-in. And we've seen it with unlicensed PCS. We've seen it with unlicensed TV white spaces. We've seen decades-long proceedings go where the FCC allocated big chunks of spectrum, set it aside for unlicensed, very low value, certainly lower than the opportunity cost was imposed, and it's taken for years or longer to get that spectrum freed up for something better in the marketplace. You wouldn't have that kind of rigidity if you allowed a more flexible, liberal system.
Professor Hazlett, you've given us a very intriguing and provocative view of how the FCC should be thinking about spectrum. Do you have any sense that the Commission is going to go in that direction? They don't appear to be doing that at all at 6 gigahertz or really anywhere else. Is there hope that this is going to be adopted?
No, not much. The politics are strong. This is very traditional politics. It's very close to a quid pro quo, which we saw in the old broadcast days. You have a well-organized constituency now that has spent a lot of time, invested a lot in cultivating the FCC policy, and they think that they're close to having something that they hope will be very beneficial to their firms, and they won't have to bid at auction to actually make they won't have to put their money where their mouth is. Now, the other side of that is that there has been an effort to maybe get possibly half the allocation for license services by the carriers. But it's very interesting that the carriers actually do have mixed incentives. That is to say, they would have to pay in an auction. And that right there is a disincentive for aggressive lobbying, that they might just be better to sit back and let other people take this who are not very competitive head to head. In fact, if they're complementary, the FCC talks a lot about the complements between the unlicensed and the licensed allocations. To the extent that that's true, and it certainly is true to some extent, then you have a situation where the incentives are for the carriers to lay back and to let this go out to unlicensed. It saves them some billions of dollars bidding against each other, and it makes sure that none of their direct competitors get access to more capacity through this mechanism, and that helps them in a competitive, or you might want to say anti-competitive way, and that they might benefit by complement that's being provided out there that increase demand for wireless services in general. So at this point, I am thinking about the long term and how we really think about getting more spectrum in this wireless age of ours, how we get more spectrum in the market. And people have to think about the benefits from a flexible liberal system that allows constant allocations and reallocations and avoids the lock-in that this and other similar FCC policies provide.
Well, great. Well, thank you so much, Professor Hazlett, for teaching us today about spectrum economics. I think we've all learned a lot and look forward to learning more from you in the future. This concludes this session of the Center for the Economics of the Internet here at the Hudson Institute. Thank you so much for joining us today.
Thank you, Harold. Stay well.
You too. Thanks, Tom.